Thank you for that introduction. We are living in very, very interesting times. To quote Charles Dickens from one of his novels, The Tale of Two Cities, we are living in best of the times and at the same time, worst of the times. Best of the times because for a lawyer like me who was practicing corporate law blissfully, not bothered much about what's happening in the society, I have been compelled to go and represent people who have been persecuted with sedition charges. And the research what I did during my LLM, I have an opportunity to put it to some good use. And any courtroom battle where you have an opportunity to prove or disprove is always an opportunity for a lawyer. So from that limited point, yes, professionally it is one of the satisfying times. But the way things are going in the society, undoubtedly it is one of the worst of the times. What to say about the constitutional values? When the most powerful court in the world, with the widest power of judicial review, which could be exercised by anybody, is silent on some of the blatant violations and everyday murder of the constitutional values. What to say in such times? While some of the high courts are making their presence felt by taking sumo motu cognizance of what is happening in the riots and by following the due process of the law in terms of giving bail to the people who on prima facie whatever the charges doesn't have any merit. But there have been instances where even the apex court has reversed such generous orders, well-reasoned orders issued by the high courts. So from that point, I would say we are living in, while there was no golden age of civil liberties in this country, but this is probably the most challenging times the Indian Republic has faced ever. I would like to talk in terms of 4 of the fundamental rights which are enshrined in the Indian Constitution and the imminent clash with religious beliefs and how religious beliefs and sentiments are actually not only curbing these rights, in fact, they are diminishing the rights itself. The rights which are enshrined in Part 3 of the Indian Constitution, they are not absolute rights. They are subject to reasonable restrictions. But at times, these restrictions could be subjectively interpreted. And many occasions when the top court in this country has put in guidelines how these subjective terms and terminologies have to be interpreted to make it more objective, they are not followed by the law enforcement authorities. As an advocate of free speech, I would like to start with the first right, which is freedom of expression, enshrined in Article 19A, 19(1) subclause A. The right is subject to 8 reasonable restrictions. starting from if your speech is going to affect the friendly relations with a neighboring state, or if it's against morality. Who defines what is morality? No wonder, till 2004, we had a very, very narrow interpretation of what is moral, what is immoral. It's interesting, question of morality arose in one of the celebrated case of the, before the Supreme Court, Ranjesh Udeshi versus State of Maharashtra, where the publisher and the seller of this book, very celebrated novel called Lady Chatterjee's Lovers, was accused of selling a book which has a lot of obscene passages. Chief Justice Hidayatullah, writing the majority judgment, he held that indeed, as per the laws which are prevalent at this point of time, this text undoubtedly is obscene. Very interestingly, the same Chief Justice, while he wrote his autobiography, My Own Boswell, it is referred as, he writes, I had the pleasure and privilege of reading this book as a student at Oxford. But unfortunately, the same judge banned it as obscene. The test or the basis on which this book was banned was on a 19th century Victorian value, which is well celebrated in a case called Hecklin's test, wherein if the material is likely to corrupt the minds of the people who are prone to such corruptions, then it is immoral. Fortunately, in 2004, this Hecklin test, which was applied in the earlier case, has been overruled. Now it is a community test, wherein under this new doctrine the court has evolved. Norms and values, they change from time to time. This case was about some of the newspapers who have flashed the pictures of Boris Becker and his fiancée, which had an element of nudity in this. But Boris Becker had a point to convey, saying that his fiancée was a woman of African origin. And the publisher's claim was that we want to make a point on apartheid. We want to arise we want to bring in awareness about apartheid and how people of African origin are persecuted and discriminated. So the court took an evolved view, saying that yes, we have to look into the community test, and values, they do change from time to time. However, the most misused provision under the Indian Penal Code is 295A. 295A, wherein if by any word or picture or any kind of a depiction, if you're causing any kind of religious hurt to people, then you would be prosecuted. Imprisonment may go up to 3 years. And 295A is so widely misused. For example, when late Bal Thackeray died, there were 2 students who posted certain things on Facebook. 295A, along with the another provision of the Information Technology Act 66A, which was applied on those 2 students. 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 2 stud 295A is only supposed to regulate hate speeches, where you have malicious intent and your whole intention is to create a repulsive feeling. And when there are two communities, you identify with a community and you are targeting another community. This provision has been widely used by people who want to persecute writers, painters, and artists in particular. Books have been banned. James Lane book on Shivaji, banned by the Maharashtra government. You have other books like a very well celebrated book written by an Kannada author called Barguru Ramchandrappa. In 2007, he authored a book, a novel, where the novel had certain observation about one of the person related to Lord Basaveshwara, one of the pioneers of 12th century bloodless revolution in Karnataka. Something to talk about his origin. And this book, in spite of the submission made by the authors saying that it is a work of fiction, I can take a historical account, nothing is established, I should be having creative freedom to say whatever I want. However, there was outrage by one of the majoritarian community from the state of Karnataka, and the matter went up to the Supreme Court, and the ban of this book as violative of 95A was held to be proper. And the list goes on, like the recent one of Wendy Doneger's book being withdrawn as it offends some of the religious feelings of the people. The interesting thing is that courts have been used, due process, it is not the end result. There's one argument made that at the end of the day, if you are writing something, then you should be ready to face the consequence. Yes, indeed. And in the long run, by the end of the day, you would be exonerated if you are, if the position, whatever you are taking, is well within the boundaries of the law. But yes, in the long run, all of us are dead. And it takes quite a long time for due process to complete. And funny things happen. For example, there is this very interesting activist who is connected with certain, the organizations which are sympathetic and empathetic to the current dispensation. This person has got access to a court, district court in a place called Dera Bassi. A place which is somewhere between Delhi and Chandigarh highway. And all cases he goes and registers in this particular jurisdiction. I don't know what secret is involved in invoking this particular jurisdiction. Now just imagine, you might have authored a book, you may be living in Kerala, you may be living in Karnataka, you may be living in some other place. You have to go and face the person in that jurisdiction. So the abuse of the due process is what is going to take a toll on the people who want to exercise freedom of expression. Another aspect which I want to talk about is the right to carry on trade and profession. In the current circumstance, you have lynchings going around. People of, if you are a Dalit or a Muslim who is caught with bovine cattle, just based on rumors and suspicion, people are lynched. I want to explain a little bit on on the background of how these laws evolved. Article 48 of the Indian Constitution talks about organizing agriculture and animal husbandry on scientific lines. It also refers to preservation of breeds of cattle. And there is one line which says about we shall bring in a law to bring a ban on slaughter of cows, calves and other milch and draught cattle. If one is able to go through the Constituent Assembly debates, it was for pure economic reasons. This provision was included in the directive principles of the state policy. First of all, it is in the directive principles of state policy, meaning nobody can go to a court of law and ask, please implement this law. It is a directive to the governments to evolve policies. And a fabulous balance was maintained in a celebrated case of 1956, in a case titled H.M. Qureshi versus State of Bihar, where most of the states in northern part of India, Uttar Pradesh, Bihar, Rajasthan, and Madhya Pradesh, they brought in laws to bring in ban on cow slaughter. The matter went up to the Supreme Court, and Chief Justice Gajendra Gadkar, writing the majority opinion, he evolved a new way of interpreting Constitution. He said that you have right to carry on trade and profession under 19(1)(g), under which the butchers and the people connected with the leather industry, they have right to carry on their trade and profession. On the other hand, there is also a directive. So we have to strike a balance. So judges evolved a new rule called rule of harmonious interpretation, where both the provisions have to be accommodated as much as possible, in which a utilitarian value of a cattle was a norm which was evolved. If bulls were excluded, so you can cull them, no problem. But cow, if it is aged above 16 or if it is of no use, subject to the certification given by the veterinary superintendent or the doctor, it could be put to, it can be culled. There was a balance which was struck. This position remained till 2005. In 2005, a very interesting case happened before the Supreme Court, where a constitution bench of 7 judges, they held the Gujarat law, which brings in absolute ban on the slaughter of the cows, to be constitutionally valid. I have done dairy farming for 4.5 years. That's how I was getting my pocket money when I was a law student. I have observed, being born and brought up in an agricultural, large, feudal household, I do know how agriculture and animal husbandry is done. The very people who decorate all these bovine cattle on the day of Sankranti, Deepavali and all, with putting tape and all the beautiful paintings on the horns, and people like my late grandfather who parade the best of the cattle in the village fair. When the utilitarian value of the cattle is no more there, they wouldn't mind going and selling it to the nearest market. I don't think they would be bothered about who is going to buy them. If the person has got generosity to maintain them, they may maintain them, otherwise they may be culled. Now, this is 2005, well before our India was still not the Lynchistan as it was referred now. A fertile ground, a very strong foundation was laid down by the great judges of the Supreme Court in 2005, leading up to what is happening now. Now, unbelievable arguments were accommodated, like even a sick and dying animal has got utilitarian value, and so on and so forth. So I wonder, the people who are bringing these kind of restrictive laws and ordinances, how will they go and convince a farmer in Vidarbha, or else say in Bundelkhand, or else in North Karnataka, where farmers are not able to sustain themselves, where farming itself is becoming unsustainable. And we have around 65% of the farmers in this country are marginal farmers. Farming itself is becoming unsustainable. How is morally possible for you to go and tell these people, saying that you may have your parents to look after, children to take care, but you may suffer, but at the end of the day, you are to take care of the cow. To hell with you and your life. How morally reprehensible this could get. Two other aspects I want to touch upon. One is that right to equality, a very celebrated value enshrined in Article 14 and 15 and 16 of the Indian Constitution. And women, as rightly pointed out by the earlier speaker, Suchithra, have always been discriminated. And when it comes to women's right, there is this bogey of Article 44 and the Uniform Civil Code. And I would like my humble submission to those people who want to rally around this bogey is that I don't give a damn about what you call this law. You may end up harmonizing the personal laws from a point of view of gender justice, or you may call it as a common code, uniform civil code, whatever the code you may have to call it. As long as women will get equal rights in terms of marriage, divorce, maintenance, property, right to enter place of worship, I don't care what name you want to call it. And be it this, the earlier aspect what I talked about it is the holy cow and also the women's emancipation. There is one common thing between what's happening in India and also in some of the other jurisdictions. There is a parallel to this. When religious morality gets equated to constitutional morality, there is always a danger and misuse. Be it the issue of holy cow or be it the abortion rights in the land of the free, home of the brave. 4 of the conservative judges sitting in American Supreme Court are hell-bent to reverse the position of Roe versus Wade, which gave right of abortion to women. This whole obsession to control women, their choices and their bodies, with whatever the regressive customary name you may call it, is reprehensible. Finally, I want to touch on right to life. In a celebrated case of Francis Caroli versus Delhi administration, the Supreme Court was very generous in interpreting the right to life under Article 21 is not for animal existence. It is to live with human dignity. And how is to live with human dignity possible if there is everyday assault from the religious groups? For example, right to put in a loudspeaker and carry on procession in unbelievable, even during late nights, causing nuisance. The whole thing is that there is this culture of privilege, that faith has got privilege. privilege to feel outraged, privilege of entitlement, privilege that you have to be extremely sensitive. You have to be politically correct while you are speaking about it. You have to be objective when you are exercising any of your rights which may clash with the religious sentiments, because you have this, we are talking about coronavirus, and before this, the most widespread virus is the virus of offensivitis, where people go out of their way to get offended. And something, okay, to conclude, I'm reminded of what Christopher Hitchens once said. Oh, you are offended. Fine, what next? You have any point to say or what? Apart from being offended. So on that offensive note, thank you all.
Neurons English is your one-stop free-thinking channel. Subscribe now and get instant alerts on videos from esSENSE Global.